Hello, good morning, Maria. Should we start?
Yes, sure, I'm ready.
Okay, perfect. So I'm sure that more people will connect in these 30 minutes. So thanks a lot, all of you, to attend once again one webinar session of the Spanish Business Council. Today, Maria Rubert, lawyer in the firm United Advocates, will explain us everything about arbitration in the UAE, all the basic information, but more important, all the update information about the situation. Currently, arbitration is a very good option for all of companies based in the UAE. So thanks a lot, Maria. It's a pleasure to have you here. So I give you the screen for you now. You are the
Thank
important.
you very much, Amaya. Thank you very much, Spanish Business Council. It's always a pleasure to share information. The moreover when is arbitration. That is my bread and butter, my pan and aceite, as we should translate it into Spanish. I've been in the UAE about 12 years. I came to do arbitration when we had the first crisis, and now things are a bit rocky. They are not as bad as they were in 2008, 2009, 2010. But arbitration is once again getting very, very busy. Now we are facing shortages of cash. So when there are shortages of cash, you also see an increase of cases, big cases, small cases. If banks don't give you money, you go after people who owe you the money. So today we are going to be looking at arbitration in 5 bullet points. I will be very happy if those of you connected now and those who will be connecting in the next minutes, walk out of this webinar knowing these 5 things about arbitration. Why arbitration and for what? When we need to think about arbitration, how we need to document our intention to go to arbitration, where we will concentrate on institutions in the UAE, and then what. If we need to talk about about arbitration, currently is the new arbitration law, and we will be going over that pretty much at the end of our presentation. And then we have a freebie. We have the 5+, and it's the fast track litigation that many people do not know about. As we will see, this is available when there is no arbitration, or perhaps when there is arbitration and the other people do not raise the arbitration clause. We will see. Everyone ready? Please buckle up. We are gonna get started. So why arbitration? Usually arbitration we have, and to stick with the Spanish flavor, we have a Spanish company that comes to the UAE and signs on a major project or little project, but 100% own UAE company or semi-governmental company, or just a company lots of years here and has the fears that in the event that there is a dispute and they need to go to the Dubai courts, Abu Dhabi courts, Ras Al Khaimah court, any UAE court, there will be no neutrality. There will be the feeling that judges based in the UAE will favor those companies or individuals with a greater connection to the UAE, the Arab factor. When we go to arbitration, we have the neutrality perception. Why? Because most arbitration institutions and arbitration rules, they prohibit that arbitrators, imagine you have a Spanish company going after a UAE company, or a UAE company going after a Spanish company or individual. If there is one arbitrator, this arbitrator will not be able to be Spanish or Emirati. So it will need to be a neutral nationality. The same if we have a 3-member tribunal, the parties could choose their arbitrator in most cases, so they could choose anyone, but the presiding, the chair, would not be able to be of either nationality. The language what do you think is going to happen if you go to Dubai courts, Abu Dhabi courts, UAE courts? They will apply Arab language. So what's going to happen to all the documents, not only the contract, and some matters, they bear significant documentation, joint ventures, construction disputes. You will need to translate every single page, and every single page will need to have the stamp of a Ministry of Justice registered translator. So this will build on costs, not only on costs, but also the grip. Will you be able to follow the litigation as closely? Everything will be in Arabic. The best that you will get will be reports from your law firm handling the matter for you. You could also ask for translations, but there is always information missing on, even if you know a foreign language, even if you are able to read, there is a flavor that is missing when it's run in another language. So language and the cost that comes with the language, then confidentiality. If you are handling a matter that you do not want anyone to know about, what's going to happen if you go to litigation in front of the UAE courts? This confidentiality is lost. And then what happens? Also, let's think, what happens if you have an arbitration and then you need to execute? So if you have a piece of paper that's the award saying company A needs to pay to company B 5 million dirhams, and then company A is not paying to company B, you're going to have to go to UAE courts to execute. UAE courts or any other court in the world where they may have assets, right? Well, there are developments on this end. For example, I have an excerpt here from ADGM arbitration rules, arbitration regulations of 2015, just for you to understand the level of confidentiality that we could achieve through arbitration. It says, unless otherwise agreed by the parties, no party may publish, disclose, or communicate any confidential information to any third party. Fair enough. Nothing in subsection 1 prevents the publication, disclosure, or communication of confidential information by a party if the publication, disclosure, or communication is to protect or pursue legal right or interest, or to enforce or challenge the award. But it says that the parties could agree to the arbitration, in the event that execution needs to be pursued, that the court will order the proceedings to be private. So no one could attend, no one would know about the arbitration under the arbitral tribunal, even when we get to the execution and enforcement stage. This may be huge for certain companies. So keep that in mind. Then expertise. If you're dealing with a matter that falls out of an affair that is very specific, I don't know, imagine there is some sort of dispute with now the COVID vaccine. Do you think a regular judge in front of the UAE court is going to know about the chemicals, what is wrong, what is right, or no? But if you go to arbitration, you could perhaps get an arbitrator that has prior experience on these matters, vaccines, you name it, right? So in terms of expertise, it's always very interesting. In the UAE, there is certain inclination for the courts to always refer matters to experts. So this builds on costs and times. So arbitration may guide you in a more straightforward direction. Then expectation. You know, if you have gone to the UAE courts, when you are inside the UAE courts, what you see may have nothing to do with how proceedings in front of the Spanish courts feel like. Spanish, US, you name the country. So when we go to arbitration, we call what we expect the McDonald factor. Why? Because arbitrations are generally more or less the same. You can agree on certain flavors or add-ons, but the hamburger is the same. And when you walk to a McDonald's, irrespective of what you are going to eat or where you are going to sit, is usually the same. You know what to expect. You know how it's going to smell. You know how it's going to taste. So this is also what you can find in arbitration, you have lawyers anywhere in the world, they will know what to expect in an arbitration anywhere in the world. So it's international commercial arbitration for a reason. And then when we talk about enforcement, this is when we talk about for what arbitration. The why we already discussed, because we have neutrality, the language is good, confidentiality, expertise, we know what to expect. But we go to arbitration because we want to enforce the piece of paper that the arbitral tribunal will issue, right? So why is not good to go to litigation? Many companies come to me when there is a breach of contract. So the first thing I ask them is, please, can you send me the contract? So I'm revising the contract and I say, oh, brilliant. It has Madrid courts. Yes, we have Madrid courts. We already went. We won. I'm like, wow, great. Well, this is good. To win a case is good. So now we need you, Maria, to execute the judgment by the court in Madrid. So then is when I have to give bad news. And the bad news is that it's very difficult to enforce a Spanish court decision in the UAE is very difficult. Why? Because if we go to the code of procedure, we will need to apply articles 235 to and following. And pretty much the UAE could say, no, I will not enforce this because a court in Madrid cannot decide a case about a company or an individual with residency in the UAE. So you may have a piece of paper that may be useless, but for arbitration is different. If you come to me and you say, Maria, no, we have an award, a piece of paper signed by an arbitral tribunal in Paris, in London, in Madrid, anywhere, then the likelihood of winning this matter and enforcing this award is greater than a judgment by the Madrid courts. Why? Because there is one thing that is called the New York Convention. More than 165 countries are members. So countries to the New York Convention undertake to execute and enforce, recognize and enforce awards rendered internationally in any other country, right? So it's easier to recognize and enforce an arbitral award coming from anywhere than a judgment rendered in any other country by any other court. And then we have the DIFC and the ADGM. Actually, we should include in here because they are free zones with their own courts and by their own rules. So until very recent, it was much better to go to DIFC or ADGM because the route to recognize and enforce was really straightforward. We will be talking about what we were facing in the UAE before the new law. So, okay, we have talked about the why and for what. Everything we do is to execute that piece of paper that says that we win, right? That's for what. When do we need to talk about arbitration? Once the dispute has arisen, I am afraid to tell you that it's too late. We need to talk about arbitration and decide to go to arbitration when we sign the contract. This is when do we need to agree on things? When we get married. How many couples agree on anything when they are getting divorced? Well, a few they do, but in my experience, it's better to agree on things when we are all happy. And this is when we sign contracts, and this is when we get married, right? So how then, okay, we talk about it at the beginning. How do we need to document in that contract that we sign that we want to go to arbitration? I'm going to share with you some real clauses that I've seen in contracts. This is one that I just saw a few weeks back. And it says, the parties expressly waive any other legal forum to which they may have recourse and agree to submit to the arbitration panel of the Madrid Chamber of Commerce or any recognized arbitration panel or authority in UAE in order to settle any disputes or actions that may arise from the interpretation of whether or not a breach of this agreement has taken place. What do you think about this arbitration clause? And by the way, the clause that we insert in a document saying we want to go to arbitration is called the arbitration clause or arbitration. And then the arbitration clause is the arbitration agreement. And why we call it arbitration agreement? Because most laws around the world and institutional rules, we will see what is institutional rules, recognize the independence of the arbitration agreement from the arbitration itself. So in the event that the agreement, the main agreement where we have the arbitration clause was to be deemed invalid, the arbitration clause, the arbitration agreement is independent and will still be valid, right? And this is already very specific. I do not want to get into the specifics of arbitration unless you ask questions, specific questions, and I would love to answer them. So please write down what you think may be wrong about this clause. We will come back to it later on, but I want you to give it a thought. We are going to be also discussing this clause. Any dispute arising out of the formation, performance, interpretation, nullification, termination, or invalidation of this contract, or arising therefrom or related thereto in any manner whatsoever, shall be settled by arbitration in accordance with the provisions set forth under the DIAC arbitration rules by one or more arbitrators appointed in compliance with the rules. The arbitration tribunal shall consist of 3 arbitrators. In the event of a default by any of the parties in disputes to name its arbitrator, the arbitrator so appointed by the non-defaulting party shall have the power to proceed to arbitrate and determine the matters of disagreement as if he was an arbitrator appointed by all the parties in dispute for that purpose. What do you think is wrong with this arbitration agreement? I'll give you a few seconds to reread if you need to. Then we have another clause that I'm hoping it gives you an idea of what we are going to be talking about after we talk about the wrong clauses. This one, all disputes arising out or in connection with this contract shall be decided by an umpire. Umpire, this I'm already telling you, it can be fine. It's called umpire in a number of jurisdictions. It's the same as an arbitrator. The umpire shall be a national of Switzerland who is fluent in English and Spanish, with an engineering degree, substantial experience as an international arbitrator, and at least 20 years experience as an executive of an international energy company. What do you think that may be wrong in this real arbitration clause? And then before we do this exercise, so yes, you will be given 2 minutes, about 2-3 minutes to draft your clause to be included in an arbitration clause. We are going to be going back. So what do you think is wrong with this clause? Well, this guy may not exist. How many nationals of Switzerland are fluent in English and Spanish, have an engineering degree, and have at least 20 years of experience as an executive of an international energy company? So what do you think is going to happen with this clause if you cannot find someone? Unless the parties agree otherwise, parties may be locked. Why? Because if I sue you in front of the Dubai court saying, listen, I cannot find this arbitrator, the court probably is not going to care. And the other party will say, hey, you Dubai court, you cannot hear about this claim because we have an arbitration clause. So you may be in the land of nowhere. You may be stuck with this clause. So what do you think is wrong with this clause? In the event of a default by one of the parties, so we have 2 companies. One company chooses an arbitrator. The other company fails to choose an arbitrator in order to choose a 3-member tribunal. So this party doesn't choose the arbitrator. So do you think it's correct that this party chosen by one party becomes the single arbitrator? How do you think this is fair and reasonable, and the parties are going to be to feel reasonably represented? No, this goes against the notions of fair and equitable treatment. So this clause is no good. And lastly, what do you think that is wrong with this clause? Do you think that we have a definite intention to go to arbitration from this course and agree to submit to the arbitration panel of the Madrid Chamber of Commerce or any recognized arbitration panel or authority in UAE? What do you think authority in the UAE is? Is arbitration? Where? I think the Dubai courts or Abu Dhabi courts are an authority. So we could be going to arbitration or arbitration or court. So there is no definite intent to go to arbitration. And how I will call this clause particularly is a pathological clause, meaning that you're in the land of nowhere and it's no good. So my recommendation is that you get a little piece of advice at the beginning. 1 hour, 2 hours of a knowledgeable lawyer at the beginning will avoid loads of lawyers and loads of hours to deal with these clauses that we have gone over. So if you are signing contracts with Dubai, UAE-based companies, you want a UAE lawyer to take a look at them. Why? Because those companies have their bank accounts here. Those companies have their assets here. So if something goes wrong with that contract and you need to go against that company, at the end of the day, the forward is to get your money back, is to execute the breach of contract, is execute the award in our favor. So everything needs to be thought in that direction. If something goes wrong, I will need to be looking into that direction. And again, we are going to think about this once when we prepare the contract, and then we're going to enjoy the contractual relationship. So we are not always going to be thinking, oh, what if something goes wrong? What if something goes wrong? What if something... No. We think about it when we do the contract drafting, then we enjoy. And we will deal with whatever happens, but we know that we have our feet on the ground. Yeah. So very good. After this little practice, I will give you, it's now 12:26. I will give you 3 minutes to draft your own clause. What do you think is important? Before you get started, let me tell you, do you think language is going to be important? Do you think that choosing 1 or 3 arbitrators is going to be important? Do you think if you want to put, for example, the seat of arbitration Dubai or the seat of arbitration DIFC, for example, or ADGM is important? Those are good tips. Give it a thought. Also, the expertise that you may want to put or not, give it a thought, and then I will be sharing with you my options. What about that? So time starts now. You have 3 minutes to try to put something into paper, and do it, please, because otherwise you will not get all the flavor out of this webinar. Okay. Anyone dares to share their findings? Anyone? One second, I'm checking if anyone has raised their hands. I don't see anyone raising their hands. Okay. So I have Richard. What will be the litigation language? Do you mean the litigation language? If litigation, we call litigation when we go to regular courts. So we go to Dubai courts, Abu Dhabi court, Ras Al Khaimah, anywhere in the UAE, it will be Arabic. That's for sure. But and the arbitration, the language of the arbitration, we can choose. So that's the beauty. You can put English, you can put Spanish, you can put anything you like when you draft the initial contract with the counterparty. So both parties need to agree. So we're gonna be looking. Thank you, Richard, so much. I hope this answers your question. If not, you can drop me another message or raise your hand. So I hope that this is how most of you felt during the drafting stage of the class. I will share my options with you. This is one. I will put, if I want to go to UAE arbitration, I'll put any dispute arising out of the formation, performance, interpretation, nullification, termination, or invalidation of this contract, or arising therefrom or related thereto in any manner whatsoever, shall be settled by arbitration in accordance with the provisions set forth under the DIAC arbitration rules by one or more arbitrators appointed in compliance with the rules. Why do you think this may be good? Why do you think this may be good? It doesn't say anything. It doesn't say anything else, the language. It doesn't say the number of arbitrators. This is a good option. I'll tell you why. And by the way, this is taken from the model clause of DIAC, which is the Dubai International Arbitration Center. Wait, to copy and paste one clause is easy. But you need to know which institution will be good for you. And you also need to know if you need to change anything from the model clause. I like this clause when it's good to use it, because at the beginning, when you say, do we want one arbitrator or three arbitrators? Maybe later on you have a dispute for 1 million dirhams, which is a relatively small figure. And having a panel of three arbitrators, this may increase the cost of the dispute. So having it by one or more arbitrators, is one or three under DIAC for sure, gives us the opportunity to comment later on and say, listen, we want one because of this, or we want three because of these other reasons. So it gives us flexibility. Also, there is no language. If there is no language, the rules will say that they will use the language of the contract. So if your contract is written in English, they will probably apply English language. Unless, imagine you sign the contract, but in English, but then all of a sudden, you start communicating in Spanish all the time. So most documentation is in Spanish. So you have, under this clause, you have a way to say, listen, the contract is written in Spanish, but in English, but we think it may be better to have an arbitration in Spanish. So this clause gives you that flexibility. Okay, 1 second before we continue. Richard is asking us to repeat the answer as he lost connection. No problem. The litigation, when we say litigation, we mean litigation before UAE courts. So that's always going to be Arabic. When we go to arbitration, we can choose. So you can put English language, Spanish language, French language, whatever you decide. Yeah. Hope this is clear. And then we have another option by another institution, which is the DIFC LCIA. And this one reads as follows. Any dispute arising out or in connection with this contract, including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration under the arbitration rules of the DIFC-LCIA Arbitration Center, which rules are deemed to be incorporated by reference into this clause. And this one gives us a feeling sort of arbitration clause. It says the number of arbitrators shall be 1 or 3. Also, keep in mind, I've never seen it, but the DIFC-LCIA has the possibility to have a greater number of arbitrators insofar as they are always odd. I've never seen it, but under DIFC-LCIA it would be possible. Next, as the seat or legal place of arbitration shall be, keep in mind that it could be DIFC or it could be Dubai, the UAE, right? Or you could put, I want to have the seat, I want to have the DIFC-LCIA rules, but I want to do it in ADGM. So you could put it as well. Or I want to do it in France. You could put it as well, right? The language to be used in this arbitration shall be, so you can choose it here, and the governing law of the contract shall be the substantive law of, here, keep in mind, one thing is where the arbitration takes place, and that's the seat of arbitration. And this is important because if something happens with the arbitration, you need to go, something happens, imagine you want interim measures, you want a party to disclose information, documents, etc. Then the arbitral tribunal will draft an order, and we will need to go to the court of the seat of arbitration to get that order enforced, right? That's important, the seat of arbitration. But the governing law is who says who is right or wrong. So if there is a breach of contract and the governing law of the contract is UK law or UAE law, the rights and obligations of the parties under the contract will need to be UK law or UAE law, whatever you decide under this clause. So I do recommend to keep it simple. So how we document our intention to go to arbitration, I think a good starting point is one of the model clauses that we decide. The difficult job is to decide which institution is good for you. That's where the tough work is, and maybe where you need legal help. So this is what I'm talking about. The most important is where. So we could have ad hoc arbitration or institutional arbitration. Institutional arbitration is DIAC, is DIFC, LCIA, or ad hoc arbitration. Imagine we have, if something goes wrong, we want arbitration in Dubai. That's a proper arbitration clause, not the best, but do you think parties are going to agree on the arbitrators later on? My guess is that the party not wanting to go to arbitration will not agree to anything, will make it as difficult as possible. So you will need to go, the party wishing to initiate the arbitration will need to go to the Dubai courts to say, hey, Dubai courts, I want you to appoint an arbitrator for me, right? So this takes time and cost, etc. So you could go to an institution. All the chambers of commerce of each emirate in the UAE have their own arbitration center. I have signaled here the ones that are most common, and it's DIAC, Dubai International Arbitration Center, under the auspices of the Dubai Chamber, or also the DIFC-LCIA, which is the London Court of International Arbitration that sits in collaboration with the DIFC. So their offices are in DIFC, next to the fitness fairs there. And then we also have ADGM, but huge disclaimer here. ADGM does not offer the same functions as DIAC or DIFC-LCIA. Why DIAC and DIFC-LCIA are good is because they first collect monies from the parties to pay for the arbitration, and then they will pay the arbitrators. But the most important is that they select the arbitrator that is right for you. So they have a pool of arbitrators. They know them well. They know their work. They know how they work. They know if they are fast, if they are not fast, etc. So they are better prepared to appoint the right arbitrator. Maybe you need a German arbitrator. They have a pool of arbitrators from anywhere in the world. So it's money well spent to go to an institution. And they will also keep an eye on the arbitration, even though they should. Once the matter has been, and this is a big topic of debate in between the arbitration community, once the matter has been transferred to the arbitral tribunal, it should be the arbitral tribunal leading. Some arbitration practitioners like that the institution revises the award. Some they don't like it. So, but the most important function is the selection of the arbitrator. They know them, they know their expertise, and they will do it quite fast as soon as payment is done. That's the trick. But ADGM is an arbitration center. What they do is that they offer themselves as the seat of arbitration, because if you have a dispute, perhaps an international dispute is better than going to Abu Dhabi courts because of the reasons, because of the whys that we discussed. And also ADGM is a common law jurisdiction. If you need to execute later on, it's quite fast and follows international standards to a greater degree, the same as the IFC, to a greater degree than the UAE courts, even though since the new law, this has changed. So we are going to be talking about that recently. So you have different animals to choose from. Usually, my experience is that if you are signing a contract with a UAE-based company, they will be reluctant to go to an ICC arbitration, ICC International Chamber of Commerce in Paris, or the LCIA, London Court of International Arbitration in London, or to any other institution out of the UAE. They feel that if the institution is here in the UAE, they have some sort of greater control. At least they know what to expect. So I think it's good to have options when you know that you want to go to arbitration. For sure, you don't want to end up in UAE courts. So it's good to have options and to know which institution offers what in order to be prepared and use it as a tool in the negotiation of the contract. You're welcome, Richard. Okay, we continue. And then the big what? The big what is the UAE law of 2018 on arbitration. Why is so important? Because before, if you had an arbitration here in the UAE and you needed to execute later on, you had a little bit of a problem. You had a little bit of a problem because once you started the execution proceedings in front of the UAE courts, in reality, what you had was another proceeding. So with the first instance, the appeal level and the cassation level. So arbitration was not very practical back in those days. Right now, the UAE arbitration law sets very forward. You include the award, and along with the translation, and you are ready to go. You are ready to execute. Why is also good? It says that the award needs to be out in 6 months. Then there are exceptions, because if you go to the rules, arbitral tribunals can get 6 months in addition. The DIFC LCIA is silent on the timings, but it's very strong on you need to be efficient, because it's in the interest of the parties, and they oblige arbitrators to sign that they have the time and that they are willing to be very fast as well. So, but UAE arbitration law sets a 6 months time frame. Also, if there is a problem, not that there is a problem, if a party wants to challenge, to set aside, to kill the arbitral arbitration award, they have 1 month as per the new law. So if they think a little bit about it, the time is out. So this means that the UAE is more now pro-arbitration. Why so important? Because investors care about this. Investors, whether or not they are going to use it, in most cases they will use the arbitration law and they will use arbitration. But even if they will not use it, what is the message that is sent about a country that has pro-arbitration regulations? The message is that they are pro-investment. The message is that they are flexible. The message is that they make things easy for investors. So usually countries that that do not welcome arbitration as much are seen with curiosity and not good eyes by investors. And that very important that the UAE is a country to the New York Conventions since 2006. At the beginning, it is true that decisions were not as arbitration practitioners we would have liked them to be. But over time, judges also need to be trained. Judges also need to know what the New York Convention is. This takes time. At the end of the day, when a country signs a treaty or a new law, these laws, these treaties are as good as the training of their judges. So now judges are very on top of the convention, and they fully respect it. So awards coming from outside, foreign awards, they are executed, they are recognized and enforced as per the New York Convention. And laws and awards that are rendered in the UAE have full coverage under the UAE law number 6 of 2018 that came into force June 2018. So again, when a new law comes into place, it may be perhaps too soon to talk about it. And this is what we are facing now with the substantive regulations for companies, or the recently announced changes reducing the Sharia requirements. When new laws see the light, it may be too soon, because we want to see how courts react to any potential problems and they apply the laws, right? One, and this is our freebie 5+. So please, I want you to remember when you walk out of this webinar today, the why arbitration and for what, the when we need to think about arbitration, the how we need to document the intention, the what, the where, which institutions we have available for us, what an ad hoc an institutional arbitration is, and the what, which is the major changes applied by the UAE arbitration law in 2018, and that now we can talk about it more amply and more precisely after we have seen the judgment by the court. So they are doing what they said they were going to do. And the freebie is this one. Perhaps you do not have arbitration. Why? Because you didn't think about arbitration when you needed to think about arbitration. And now you have a dispute on payment, right? You have a dispute on payment, be it checks or invoices. Invoices, you send the invoice and they tell you, yes, thank you, Maria, we are short on cash, but we will be making payment shortly next week or next month. They are not challenging the concept of the invoice. They are not challenging that we didn't do a proper job, for example. They are accepting, and they are just getting time to pay it. This, or you have a delivery note, you have delivered items, and then you don't receive payment. So when you have an unchallenged debt, you could initiate the fast track payment. So this is to request a payment order. And the cool thing is that you could get a decision within 3 days. And then once the decision is out, the counterparty would have 15 days to appeal. But if the debt is unchallenged, there is little room for any appeal whatsoever. So this is, in a month, you could have a decision and you could be after monies in the event that you don't have arbitration. It's not so bad. Keep in mind that some people may think, oh, this is very cool, so I'm not going to put arbitration. But think that most disputes are not unchallenged. Most disputes, construction, projects, in most cases you have, listen, this is my claim, I want this payment. And on the other side, you say, hey, I'm not paying you because you didn't do what you were supposed to do. So it's generally not as easy as to get payment of an invoice. But I think it's important that you know that this exists and that is available. Keep in mind, some clients have arbitration clauses, and then they could fall into this fast track. They could pursue it, but if the other party presents into the proceedings and say, hey, we have an arbitration clause, the judge will close the matter, right? In any event, I think if I had to choose, I think it's better to plug in an arbitration clause and run the risk that I may not be able to avail of this possibility. But keep in mind that the non-challenge has to be completely, without a doubt, clear. If there is any ample room to think that the debt is challenged, you will be sent back to the regular process, and this takes years. Okay, any questions? This is the end of the presentation. To be able to stick into the 1 hour timing, giving you a few minutes for additional questions, I will be very happy to answer them. Okay, we have one question in form of Q&A. If the invoice has been sent and received by the client, but the client doesn't tell you when it will be settled, can this invoice be considered as unchallenged? I think you have a good chance to call it unchallenged, because what it would be reasonable when you buy an item and you inspect the item and there is something wrong, you usually reply within 7 days. Something reasonable, 7, 8, 15. Better if it's 7, unless there is a small letter in the back and forth between the orders that says 48 hours, whatever it is. But you disclose it. There is something wrong with this, and this is why I'm not paying. In the absence of such disconformity with the goods, I think you have a good chance to claim that is unchallenged. I hope this answers your question. Any additional questions? Let me check for the hands. No hands. I think this will be it, Amaya.
Yes, Maria.
I hope you have enjoyed a little bit.
Yes, it was amazing. You know, I'm not a lawyer. I don't have any idea about law, but it was very instructive. You know, I follow everything, and I think it was really on earth. So it was great. I think that we really understood what is arbitration, and that our audience can get some clear ideas at points that they can do. So for me, I think it was amazing, Maria.
Thank you.
Thank you very
so
much.
Amaya, I appreciate that you thought of me for this webinar. It's a pleasure to share information about my practice and my field. So I'm at your disposal for anything we can build on. And those, just a message for those in the audience, please, if you have any questions about arbitration, feel free to send me an email. I will be very happy to answer. I know some questions sometimes don't come up on spot, but at any time, please. Thank you for your time today.
Thank you. Thank you. We will also upload the video in our YouTube channel. So perhaps people that finally couldn't attend will have the opportunity to watch on our YouTube channel.
Great. Thank you very much, Amaya. Okay. Thank you very much, Spanish Business Council.
Thank you, Maria. Thank you very much.
Have a good day.
You too.